My name's John Hawley. I'm an attorney and mediator and co-founder of Conscious Family Law and Mediation in Colorado. And since opening our doors in 2014, our lawyers have helped hundreds of people through the legal process of divorce. And in this short webinar, I'm going to provide an overview of divorce in Colorado and some of the options for moving through that process. So first, a disclaimer. This webinar is not legal advice. Specific questions about your case should be addressed to an attorney with whom you have an attorney-client relationship, and no such relationship is formed through this webinar. Okay, so there's two main approaches to the legal process of divorce. One we could call the conventional process, which could include lawyers or not. If you're not using a lawyer, you are referred to by the court as pro se. It's a Latin term meaning on your own. Second main approach is a mediated process, or sometimes a collaborative process, which could include lawyers. And I'll talk about these more in a minute. Okay, but starting with conventional divorce, what does that look like? Well, first of all, in order to pursue a legal divorce in Colorado, one spouse has to have been domiciled in Colorado for at least 91 days preceding filing a petition for divorce, before the court will have jurisdiction and authority over the case. First real step is to file that petition. And if you're just filing on your own, you'll have to also prepare a summons to serve on the other spouse, and you'll pay the court the filing fee, currently $230. So as I mentioned, that you could file this petition on your own as an individual. If you file it together with your spouse, it's called a co-petition. Either way, the petition must claim that the marriage is, quote, irretrievably broken. Making service of the documents to the other party, if you have not filed it together, is a required step. You can't just hand divorce filing, the divorce petition and the summons to the other person, the other spouse. It has to be served on that person by somebody else, by a third party who's 18 or older and not a party to the case. So this is often the sheriff in the local county. Costs about $40. But if it's going to be difficult to serve the other party, it can be useful to hire a professional process server, a private process server. If it was not a joint co-petition and the other person was filed and served, then they have to file a response. And there's a court filing fee for that response of about $116 currently. And then it will be a minimum of 91 days after service before the court can issue the decree. And a number of things have to happen before the court can issue that decree. And sometimes, often, it takes longer than the minimum 91 days. We'll talk more about that. Okay, when you file a petition with the court, there's something that immediately comes into play called the automatic legal injunction. What is this? It means without consent of the other party, no transactions can occur outside of, quote, the ordinary course of business, or for, quote, the necessities of life. So it sort of freezes the financial circumstances in place, more or less. Neither spouse can change insurance policies or allow insurance policies to lapse because of non-payment, can't change beneficiaries, things like that. Can't take any children out of the state, again, without consent of the other party to the divorce. And neither spouse can disturb or molest the peace of the other spouse. So all these things go into place automatically upon filing of a petition with the court. Okay, so for a timeline, so once we file that petition, first deadline is 42 days after filing, about 6 weeks. There is what's called the Initial Status Conference, or ISC for short, and that's also the deadline of the financial exchange. There's a number of required disclosures, fairly burdensome list of financial documents and information that have to be disclosed between the spouses. And then you have to file the certification with the court that you've completed this step. 63 days before trial, and the trial date will be set usually at the initial status conference based on court schedules and docketing, depending on your county. But statewide in Colorado, 63 days before trial, that is the deadline at which point each party needs to file, or rather to at least serve the other party with the list of any witnesses that they will be calling at trial, and to what's called propound or issue discovery requests to the other party, and which means any information that's needed that was not part of the initial round of the mandatory financial disclosures, for example. The deadline to respond to those discovery requests is 35 days before the trial date. Now, sometime in this timeline, and it depends county by county, when temporary orders can be held. But if there are urgent issues with respect to temporary payment of financial obligations to third parties, or temporary child support or spousal support, or temporary parenting arrangements, things like that, because it can be up to 6 months or more before you have your trial date. So sometimes a court can schedule a temporary orders hearing to address any of these issues. So that might happen sometime during the process. 21 days before trial in Colorado is in family law cases. There's a mediation requirement. So you have to at least try to resolve all issues, or as many issues as you can privately through negotiation. And you have to try using a mediator to do this before you appear in front of the judge for your trial. Some parties are can be excused from this requirement. For example, if there's a restraining order in place, or other reasons why mediation is not appropriate or possible. And then, as I said, usually 6 to hopefully no longer than 9 months, depending on your county, you'll have your trial date 6 to 9 months from date you filed the petition. A little more about the initial status conference. So this is also the time, in addition to scheduling the trial date, that experts will be appointed if needed to evaluate things like custody matters, real estate values, potentially a vocational evaluator if someone's potential income from appropriate employment is in question, which is important in determining support amounts and needs, and other valuation experts potentially to value things like a business or a trust. As I mentioned, the court may also set a hearing for temporary orders, if necessary, on some of these matters, including maybe who's going to have the right to possess the marital home. Sometimes attorney's fees can also be awarded or shifted between parties if one party has access to financial funds that the other doesn't. And as mentioned, setting that date for the trial. Okay, what needs to get worked out in your divorce? We call this the substance of the case. So one of the big ones is property division. So things, the things and the assets, including debts that were accumulated during the marriage. So separate property, it has to be identified, and this means it wasn't accumulated during the marriage, meaning one person brought it into the marriage, or even if it was accumulated during the marriage, if it was inherited by just one person or received as a gift just by one person and it remains in that person's title, it may be identified as separate property, and that stays with the owner. That's not divided between the spouses. Marital property does get divided between the spouses. In Colorado, it's an equitable division state, which means it has to be divided fairly between the spouses, and the court or the judge is the final arbiter as to what is fair and equitable to divide the marital estate, as we call it. Maintenance is another word for spousal support or alimony, as it's known by the IRS. Before we get to tax issues, spousal support is the threshold being if one spouse is exiting the marriage lacking sufficient income to meet his or her reasonable needs through appropriate employment. And in that case, the marriage may have an obligation to help support that person meet their reasonable needs for some duration. And it's based on, the duration would be based on how long the marriage lasted, and the amount would be based on reasonable needs in the context of the marriage, lifestyle of the marriage, and the reasonable expenses. Tax issues need to be determined, how a couple is going to be filing for the prior year and any year in which a divorce decree is issued. The spouses will then no longer be filing a joint return, and they will be filing individually. But any refunds or liabilities that are outstanding need to be addressed. Health insurance is sometimes an issue to be addressed as to whether it's possible to continue covering one spouse on another person's group health plan. Things like that sometimes can be addressed. Any children of the marriage need to be addressed in a parenting plan, which includes a parenting schedule, so a regular schedule of who's caring for the children and when. Holidays, vacations, summer schedules that's can deviate from the regular schedule and can be worked out separately. Child support has to be addressed, worksheet prepared for the court to review and approve. It's a fairly straightforward, but not necessarily a simple calculation. There's a free calculator on the court website. It's not that easy to navigate, but it's based on gross incomes of each parent, and then the overnight schedule, the annual overnight schedule of which parent will be caring for any children overnight. Parenting schedule will sometimes also address third-party caregivers, if not the parents themselves caring for the children, which can include nannies, grandparents, new partners of a spouse. So as you can imagine, sometimes a bit of an emotional conversation to navigate. Parenting plan will also include decision-making for the children over major issues. The basics are activities that would require a parent's signature or approval, medical decisions, religious training, if any, and educational decisions. A lot of parents will add to this list that they want to allocate decision-making over things like bodily appearance of their children, car privileges, cell phones, dating, media, social media, discipline. By agreement, parents can add these areas. And decision-making can look different. It can be, by agreement, it can be joint decision-making between the parents, or it can be allocated to just one parent. If parents are going to be joint decision makers, it can be important to include a dispute resolution process, the court being the default arbiter of any disputes between joint decision makers. Often parents elect to allocate decision-making authority to resolve disputes to either a private arbitrator, or will at least elect to require mediation before taking the issue to the judge. And lastly, some other issues that will often be addressed in a parenting plan will be if there's any substance abuse issues by a parent, maybe there'll be thresholds as to whether parenting time can be exercised. Sometimes a parent needs to demonstrate sobriety, for example. Another issue can be how and when any new romantic partners are going to be introduced to the children. And there's many other issues too, and that are often addressed in parenting plans, but these are just some of them. Okay, so what is mediation? Is one of the two main alternatives to the conventional process, where all these issues are maybe attempted to be negotiated privately by the parties or between lawyers and then taken to the court. So a mediator is a neutral third party. That means mediator is not representing either party or advocating for either party, but they're neutral to the two people and facilitating conversation between those two people. The mediator does not make any decisions for either party, but is facilitating the dialogue and hopefully helping the parties to reach their own decisions. If the mediator is an attorney, it's important for the parties to understand that that attorney is not representing either of them or both of them together. So the attorney is not functioning in the traditional way and it's not giving quote unquote legal advice to either or both parties. But that attorney mediator can provide legal information, can bring their expertise into the room and speak neutrally to the parties in service of helping them develop and evaluate their options for settling their case and all the issues in there. Hopefully, if the parties come to agreements, the mediator can help prepare the written settlement, so memorialize the agreements that the parties have reached in mediation. Mediation is confidential and private. Mediators cannot be called as witnesses. Their notes can't be subpoenaed. This is protected by statute in Colorado. And this This helps people feel safe that they can be creative and discuss issues and without fear that something they say is going to be used against them in court. One of the main benefits of mediation is that the process avoids litigation, meaning a court battle. If you can work things out with the help of the mediator, and it can also avoid the cost of hiring attorneys to work out all the issues. Especially if you hire an attorney mediator, this attorney can help you understand the legal landscape and maybe avoid having to hire two attorneys to help navigate the whole process. It is highly advisable and recommended for each party to have an independent lawyer to review any final legal settlement before it's filed with the court. The collaborative process is another settlement-oriented process. It is different than mediation in that it generally involves having legal counsel, so two lawyers on both sides. These lawyers, if a collaborative participation agreement is signed by the parties and their lawyers, it means that the collaborative lawyers can't litigate. They can't take the issue to trial. They can't represent one party at trial. This is a strong incentive for everyone to work hard to settle the case out of court, because then if settlement breaks down, the collaborative lawyers have to withdraw, and the parties would have to start over with new attorneys if they're looking to take the issue to court. So it's strong motivation to settle. In Colorado, the collaborative process usually includes a neutral coach or facilitator to organize the meetings, the settlement meetings, and to help navigate the issues. And also a neutral financial advisor, which also can be part of the mediation process. Often, a financial advisor a neutral financial advisor can also come in to the mediation process. It is probably a confidential process, but there is no statute governing collaborative divorce in Colorado at the present time. If you have questions coming out of this webinar, we are available to help answer your questions. At Conscious Family Law and Mediation, we offer a free introduction call to help you understand the options available to navigate your divorce in Colorado. And so you can find out more about us and get scheduled for that call at consciousfamilylaw.com or by calling our office at 303-415-2040. Thanks so much for your time and attention, and I wish you the best of luck in your divorce. Thanks so much.